We want to say thank you for everyone for coming out, and this is a very interesting topic. So first we have Judge Gallagher here to talk to you about probate. She is the probate court judge, and so she'll be talking to you about what she does in her courtroom. Thank you.
Good afternoon, everybody. How is everybody? Can you hear me okay? I'm a little nervous. We got lights, camera action here. So I am Judge Laura Gallagher. I'm one of the two probate judges in Cuyahoga County. Anthony Russo is the other probate judge. And we are housed right down the street in the old courthouse, the other building that looks like this building. So when people are coming to see me, they come here by mistake and vice versa. But the court has worked with the county to put together this program we call Great Estates. And basically, what we're trying to help you do is avoid me. I'm not so awful. If you do have to come to my court, we can help you. But the point of getting out and talking to people is to let you know things you can do now, either you for yourself personally or to help your loved ones get done, so that when we get to the point of death, which nobody wants to talk about, nobody wants to think about it and put it on paper like, okay, I'm gonna die and here's what I want to happen when I die. That's not like the first thing on our agenda every day. But if we take some time now and make plans, when death comes, the last thing you want to be doing is looking for documents, looking for folders, digging through someone's, my dad notoriously had a messy office. What do they say? Like it's a sign of a genius or something. And he took that seriously. And, I think days it took to get through his paperwork. And that's not what you want to do when someone you love dies, or it's not something you want them to have to do when you pass. So we're going to just provide some pretty basic information about the things that you can do, and some of it you can do easily and free on your own. Some of it you may need to talk to an attorney, and we have an attorney that will be here to give some more information about services that attorneys provide. But just to get your minds going, hopefully some or all of you are fortunate enough to own a home. Okay, so we're going to talk about houses. What happens to your house when you pass? And the difference between, if you're married or if you're not married but you have children, start thinking about the people in your life that should be able to have your assets when you die. But not just houses. I mean, that's usually the most valuable thing that we own, but cars, bank accounts, investment accounts, insurance policies, anything that you own. So think about, just in general, everything that you own right now. Is it in your name only? You're the only name on that account. You're the only name on that house. You're the only name on that car. If you are the sole owner of your property, when you die, that property will have to come to our court through the probate process to be distributed, either according to what your will says, or if you don't have a will, according to what the state of Ohio tells us how we distribute property. So anything you own in your own name is going to come through probate. Anything that you own that you've taken the time and the steps to have either a co-owner, joint owner, or a beneficiary doesn't have to come to our court. Things can pass very simply after death. You get the death certificate, you present that, and if you are the beneficiary, then you can go ahead and get that property, that money, that car, that house, without a lot of money, frustration, time, and so forth. So that's generally what we want to talk to you about. Because I'm in the probate court, and I tend to see, as the judge, all the things that went wrong, not all the things that people did right to plan. I'll caution you on some things. If you are going to name other people on your accounts or your house or your, anything that you own, be careful if you're naming them as a joint owner. We see this quite often in our court where people will put their kids or their friend on their banking account to help pay bills, to, in case they're in the hospital, somebody can access their money. If you put somebody on your account, they're a co-owner. That doesn't always go well, okay? If you don't have somebody that you 100% trust to jointly own your property, you can simply name them as a transfer on death beneficiary. That way, it's all yours until you pass, and then it can go to that person after your death. So I like to caution people about that. The other kind of bad thing we run into is when you have a combined family. So you're married or you have children from your first true love, but that true love doesn't work out, so then you remarry and you might have more children, or your spouse might have children. When we're combining families, that is where we see a lot of fights over money and property. So I always tell people, I was lucky enough, my parents were very open, and we always, from the time I can remember, we had the family meeting, right? Somebody got in trouble, we all had to have a family meeting and talk about it. Something was going on in the family, family meeting. So a few years before they died, they brought my brothers and I together, and they gave us copies of all their paperwork. We had their will, their powers of attorney, a list of their assets. So we knew at that point what their plan was. And when they passed, it made it so much easier. We weren't going to fight. And we knew what there was. We didn't have to go searching through so much paperwork to find what they owned. So these are all just things, the more open you are, the more organized you are. If you can kind of have a list of your assets and how they can be, found and that kind of thing, that will, even if you have to come to our court, you'll spend far less time, far less money. Now, if you do have to come to probate, and sometimes despite all your best planning, you're still going to have something that doesn't have somebody else's name on it. So a coin collection that's worth something, jewelry that's worth something. Sometimes it's a refund from your last year income tax. Sometimes it's a refund from somewhere else if you had paid for something and then you died and you get that money back. Sometimes those kind of things will have to come through probate. If it's a low amount, you might not have to go through the whole probate process. So the less value that has to come through our court, again, the easier it is, the quicker it is, and you can move on from doing things you don't want to do. So the more that you can designate, the better. If you do need to come to our court, we are pretty user-friendly. In Ohio, we use what are called standard probate forms that are available on our website and the Supreme Court website. So no matter what county you live in, or whoever's taking care of your property in Ohio, we all use the same forms. The only thing different on the forms is the name of the court and the name of the judge at the top. So you don't have to recreate the wheel. Most of the probate courts in Ohio have very helpful websites that will have information about everything we do, what you need to bring with you when you come to file your paperwork. There's checklists, there's instructions. In our court, as in many courts now, you can actually e-file everything. If you know how to use a computer, I'm a little shaky on the e-file, but it must be easy enough to use, because most people now that file in our court do it from the comfort of home or their office and e-file everything, so you don't even need to come down to the court. I will tell you, we have a court resource center. We have attorneys that take a stipend, not a lot of money, but they'll spend a day a month at our court to help people, not if it's a contested matter. So if there's a big fight over the will, or there's a big fight over who owns the house, our resource center cannot help you, because we have to keep an open mind and we can't help one person and not the other party in the dispute. But if you just need simple help with, there's a car, the only belonging is a car, we just need to transfer it, you can come to our resource center, you can make an appointment, and an attorney will help you know what paperwork you're supposed to use, how you get it filed, and what to expect next. So we're pretty user-friendly, but again, we have a lot of work. The baby boomers, unfortunately, are hitting I'm on the younger end of the baby boomer stage, but we have a lot of people coming in that either need guardians or other kinds of assistance, and then, eventually are passing. So we have plenty of work, and anything we can do to help you all avoid us, the better. So again, having a will, some people ask, well, I really don't have anything and I have beneficiaries on all of my belongings. Do I need a will? I think a will is always going to be helpful, because the will, if nothing else, it names who your loved ones are. It says, I have 3 children, here are their names. I have a spouse, here's their name. So even if we don't have to go through the whole probate process, if we have a copy of your will, you might find this hard to believe, but sometimes a person will come in and they want to do a quick estate because it's not a lot of money, and there's a form you have to fill out that lists all the next of kin. Sometimes people forget they have a brother or sister. It's unbelievable. In the moment, they just forget that there's other people who might share in this. So if you have a will, the court can see the roadmap. Here are the people that were supposed to benefit from your assets. So it's always a good idea to have a will. They're not expensive. Attorneys will usually prepare a will for you fairly inexpensively because they want to be your family attorney. They want to, help your family when you pass. So a will is a great thing to have. Mr. Gibbons is going to give a little more information about estates, so he may touch on trusts. Not everybody needs a trust. We all, it used to be get a trust, avoid probate. That doesn't always work because I have as many trust contests as I have a will contests. And when we have a contest, usually what it means is somebody was twisting mom or dad's arm. Somebody was saying, I'm your favorite kid. I took care of you at the end. I should get everything. You give me everything, or I'm going to put you in a nursing home. I mean, every day. This is the kind of will contest I have. So again, the more transparent you are, talking to an attorney who can later say, oh, I met with them, they understood what they were doing, they were competent to do this, then things go more smoothly for your loved ones. So I'm going to turn it over. I'm just looking to see. We will take some questions, I think, at the end, and I'm going to stick around, and I'd be happy. Please don't ask questions about pending cases. I'm not allowed to do that, but general questions about our court or what services we have and so forth, I'll be able to answer, but you may not have as many questions after we move through the process. So I'm going to turn it over to Brian, who's going to talk to you about how you can title your house, what to do with your house so that it can pass without having to come to the probate court.
Thank you, Judge Gallagher. As Judge Gallagher just mentioned, my name is Brian O'Malley. I'm the Director of Transfer and Recording for Cuyahoga County, so it's in our government, since we're a charter government. I'm the county recorder, plus the auditor, plus the engineer. Pardon me. So, types of ownership. There are basically three types to avoid probate. You can own it as survivorship. You can own it as, this is cut off a little. Transfer on death designation, or in a trust. So these are three but as the judge mentioned, sometimes if there could be a dispute over the trust, nothing's foolproof. However, survivorship and transfer on death are, will take your property and make it a non-probate asset. So I think it was 1828 was the first time the idea of a survivorship tenancy was broached to the Ohio Supreme Court. 150 years later, the Ohio legislature created the estate by inheritance deed in 1971. So this type of deed lasted till 1985 when it was abolished. But it was pretty popular because you were limited. You had to be a husband and wife, but it also provided creditor protection. So if you bought your property before then and have one of these, they're still valid. All the same protections apply and the same rules apply. If one person passes, one spouse, it automatically goes to the remaining spouse. So that led way in 1986 to the modern survivorship deed. Now the difference with this is it's two or more people. They do not have to be married. You can put, three siblings could go into a survivorship together. And if one of them passes, it immediately goes to the remaining two. The key is you have to look at the deed to your property, because you might have bought it out of an estate, so it might say fiduciary deed or executor's deed. It could still be a survivorship deed. The key is how the person takes title, where it'll say like John and Mary Smith and to the survivor of them. So you're looking for that language, for their joint lives remain to the survivor of them. So if that language is on any deed, no matter what type, warranty, limited warranty, quitclaim deed, it's a survivorship deed. So this is what happens. This is if one of the parties passes in either of those two deeds. This is the document, and all these documents are available on our website at the county. This is what you would fill out. This is what the document you would complete if one of the people had passed. So basically, it's just a basic affidavit stating that John and Mary own the property, that John has passed, and due to that death, Mary is now the fee simple owner. You get it notarized, file it with our office, and that's it. So the transfer on death deed was established in 2000 by the Ohio legislature. This deed had some problems with it because, you could have to choose one or the other. You had to be in a transfer on death or a survivorship. You couldn't have both. So a lot of times there were errors made back then in the first few years of filing these where they would put this language, like to the survivor of them, transfer on death too. Well, they were competing tenancies. So this was just a survivorship deed. The transfer on death wouldn't have applied. So since that became such a problem, and I think there were a lot of people that complained, the legislature adopted the transfer on death affidavit, which is in our handouts that we gave you. Inside the folder, there's that for one for your house and one for your car. The transfer on death affidavit is a lot more flexible. So you can have your survivorship, it's still intact, but then you can also, you and your spouse or whoever could name their beneficiaries who they want to get the house, and it would go in that order. The survivorship to if one of the surviving tenants passed, it would that be the sole owner until that last one passed. Then this document would kick in, transferring it to whoever they list as their beneficiaries. The other advantage is you can choose how they inherit it. So over on the right, you listed the three children there in this scenario, and they each get a third, and then it's tenants in common, meaning that if one of them were to pass, it would go to their children. You can also choose that they inherited a surviving, which means if one of them passed, it goes to the remaining two. So it gives you a little flexibility as to how you want to determine who gets your property. And this is the document that after someone passes due to a transfer on death, that would put the property into the beneficiary's name. So again, it's a simple form. It's on our website. You can complete it. You don't need to have an attorney or anything to fill out it. It's just a simple affidavit. It gets notarized and recorded with our office, and then the beneficiaries are now entitled. One of the questions that comes up is, can you list a trust as a beneficiary? And yes, you can. It's important to note that you have to name who the trustee of the trust is, because a trust by itself can't hold title to real property in Ohio. And this is another big problem that's been throughout the country, really, is deed theft. So most of you, if you live in your property, they're not going to target you. Usually what they look for is empty homes, and then they look up to see who owns it. They forge a deed, file it, and then usually either try and flip it to an unknowing buyer, pocket the money and disappear. There's a handful of different scans. So if this is a free service, if you go to our website, you can flag your property and you'd get notified in instant email if anything's ever filed against you or your property. So at least you'll know right away, rather than we've had people find out, like a gentleman was flying in from Florida to check on two or three of his rentals, and there was someone changing the lock. And he's like, "Can I help you?" And she's like, "I own this property." And I'm like, and it went from there. So, and I said that the other document that's in your handout is you can do a transfer on death beneficiary for your car. You can add beneficiaries. If there's a lien, you have to check with the lien holder to access it. Rights of survivorship. All title possessions can be transferred to surviving if there's more than one of you entitled to the car. And this can be added even if there is a lien. And surviving spouse, if you have a spouse pass, you can bring the death certificate into any of the auto title branches, and they can transfer the property. And I thought there was one, but I was going to go right back to show you the addresses. They're kind of cut off, but there's 5 downtown, our main office. There's Mayfield, Parma. I believe. Sorry, I can't see the other two. They're in the. All the addresses are on the trifold, the handout, the brochure you have. So, but that being said, I would now like to introduce Tim Gibbons, who's going to go a little in depth on estate planning. Thank you very much.
Oh, okay. That's me. Thank you. I'm the smaller of the three, and I go last. I'm going to talk to you about the probate process and what kind of documents you need. The probate process is a process in which the decedent's assets are transferred to an heir or a beneficiary. That process goes through the probate court. Look at the probate court as a policeman to make sure that your wishes are carried out. Because you're deceased now, you died, you want to make sure there's a trusted organization that's going to make sure that your assets go to the people that you wanted to go to. If you take anything away from my speech, it's this. Probate assets, non-probate assets. Probate assets are assets that are in the decedent's name only. An automobile, a checking account, real estate, maybe some stocks or bonds. That's a probate asset if it's in your name only. You cannot go to the bank. If your dad died and you're going and he had a checking account in his name, you can't go up to the bank and say, here's my dad's death certificate, give me his money. I've had a client do that, and what the teller did was press the button, the panic button, where the police came because they thought she was being robbed. You have to get, and the bank will tell you this, you need letters of appointment. That's a court order allowing you to transfer those assets. That's a probate asset. A non-probate asset is when you have a designation, a beneficiary designation. As Brian was saying, you have the transfer on death deeds, joint with right of survivorship deeds. Those pass outside of probate. They are not probate assets. So that's a simple affidavit. You know, same thing with your checking or savings accounts. Those are, if you have a designation payable on death or joint with survivorship, that passes outside of probate. So that's a good thing, I guess. So that's a non-probate asset. So now I'm going to talk to you about 3 essential estate planning documents one might want to consider. The first is a will. First of all, how many people have a will right now? 1, 2, 3, 4 people. That's about right. 60% of the people in this country don't have will. In this country, don't have wills. 60%. Only 40% of you guys have wills. Those of you that don't have wills, you're probably thinking, I'm pretty smart. If I don't have a will, I can't die. Because how are you going to pass out my assets? That's not true. Ohio has a will for you. It's 2805.06. It's a very, very basic will. Everything, when I die, everything goes to my spouse. My spouse predeceases me, then everything goes to my children. When I don't have any children, then it goes kind of up their children, if they have any children. If you don't have anything going down, you start going up the tree. To my mom and dad. To my mom and dad, then to the grandparents. But if you don't have any grandparents, usually you don't. It goes to your sisters, brothers and sisters. So it starts branching out to the tree that way. That's 2105.06. That's Ohio's will. I call it Ohio's will. It's very basic. Usually when people come to me, they want to do a will. A will is a document that you actually express who you want money or your assets to go to. It could be your next door neighbor. I just did a will the other day where the individual wanted her caregiver to get some money. So we added her caregiver to get $20,000 because she does everything for her, not her kids. That's another story. But anyways, it's a will, it's a document that you actually say to a person, I want this in writing. This is how I want my estate to be distributed. It's a will. You name an executor. An executor is an individual who makes sure that that will goes to the probate court, and it's where the probate court says, now, Mr. Executor or Mrs. Executor, you're responsible. If you do anything wrong, I'm the judge. I'm gonna hold you to it. That's what an executor is. So you have to appoint an executor. Make sure it's a trusted person. A lot of times people will say, I want to name my son the executor. I said, well, why? I always ask, well, why? Well, he's the oldest. This is the oldest might not be the best person to name as your executor. I come from a family of 5 kids. I'm the second youngest. And it hurts me when my mother says I want my sister to be the executor. I'm the smartest one in the family, for God's sakes. Why not me? And I'm trustworthy. I am an attorney. Anyways, you name an executor. How do you make a will? Well, a will, you have to be at least 18 years of age or older. I would say some of you might not be 18 yet, but if you have to be 18 years of age or older. You cannot be under any restraint. You have to have, you can't be under any restraint or undue influence, and you have to be competent. It's got to be signed by two, and I say this, the law doesn't specify, but it has to be signed by two disinterested witnesses. And usually it's in writing. I did a report one day for the judge that I used to work for. We wanted to see, does it have to be in writing? Because nowadays, today's day and age, there are some states thinking about doing your will online or something like that. Ohio hasn't gotten to that point yet. But there was, what's a writing? A writing could be a Burger King receipt, a blackboard, although some states say no. I actually found one where they had a will was admitted to probate. It was a bedpost. It was a bedpost. The guy said he wanted, and he carved his name, he signed it. And don't forget, I'd love to have been a fly on the wall on that one because it's got to be witnessed by two people. So there are odd ways to write a will, but usually it's paper. And of course, like I said, a will, if you do it correctly, doesn't have to be revoked. It's valid for the rest of your life. It's valid for the rest of your life, unless you change it, unless you revoke it. So you can do that. But it's usually valid for the rest of your life. And it can be changed at any time as long as you're competent. As long as you're competent, you could change it if you want. But I usually try and draft a will where it's going to be good for the rest of your life. Another document that I want to talk to you about is the financial power of attorney. Talked about that. Financial power of attorney is a document that takes care of your finances while you're alive. While you're alive. If your spouse passed away and you have children and you're all alone, maybe it's a good time to do a financial power of attorney. You don't have to. But it might be good in case you're incapacitated somehow and you need someone to pay your bills. Maybe do some investments or talk to the person about your IRAs. So it's a good idea to have a financial power of attorney. Financial power of attorney, when I started a long time ago, I've been an attorney now for almost 35 years. The judge I used to work for said a power of attorney, and I'm dating myself, power of attorney is more crime is committed with a power of attorney than a Saturday night special. Now, a Saturday night special used to be a gun, but that was a term used back in the 80s. They've changed that a little bit now. Since 2012, the Power of Attorney Act, I call it, in 2012 changed a little bit. There are some safeguards. So in order for you to, if you want to put gift people, you have to designate, yes, I want to give gifting. I want to change my estate plan. I want to, what else do they have? Create a trust. Give away property through my gifting powers. You have to specifically say that. Change right of survivorship. Not a lot of people want to change rights of survivorship. Change beneficiary designations form. Waive a person's right to a beneficiary under an insurance policy or an IRA. Those you have to specifically say you want or deny. So financial power of attorney has become a little more safer, but you got to be careful. Again, if you're going to name someone as an attorney in fact, or someone to act on your behalf, you better make sure you trust that person. I also want to make sure that you name a successor attorney in fact, in case that first one is unavailable. The third document I want to talk to you real quick about is a healthcare power of attorney. A healthcare power of attorney is a document that you're saying, I don't want to be kept alive through machines. I don't want to be put on a machine. Now, there's some restrictions to that. People shy away from that. But I tell them this. If you're sick, you have COVID, you just had COVID, or you have a heart attack and you're going to the hospital, they're going to try and save your life. They're not going the healthcare power of attorney, or sometimes known as another document, a living will, does not come into play at all. Doctors will try and get you better. The only time a healthcare power of attorney comes into play is if you slip into a coma, or you're terminally ill and you slip into a coma, and the doctors perform tests and find out that you no longer have brain function. The only alternative is to put you on a breathing machine. That's when the healthcare power of attorney comes into play. And not only that, the doctor has to get a second opinion, someone to sign off on that. That's when the healthcare power of attorney takes place. It's not because you're in nobody comes into your hospital room and unplugs the machine and walks away. It doesn't work that way. It's just you saying, listen, if I'm on a machine, and I'll be on the machine for the rest of my life and will not gain consciousness anymore, I don't want to live that way. It's called dying with dignity. That's what a healthcare power of attorney is. A living will is they have the doctors make that decision, but before they make that decision, they have to notify you or the next of kin in case they want to go to the probate court to challenge that. In the 9 years that I was a magistrate, I only had one time where somebody challenged that. Only one time. So those are the estate planning documents that I want people should really think about. These are very inexpensive documents. Now I want to talk to you about the white elephant in the room when we talk about estate planning documents, a trust. Everyone's heard of a trust. What is a trust? A trust is a document, a very elaborate document, 20 to 30 pages long sometimes, where you, as the grantor, transfer your assets into a trust. You should relinquish your assets. And you name a trustee. It's usually yourself. I'm the grantor, I'm naming me as the grantee, and guess what? I'm the beneficiary. However, this document is a very elaborate estate planning document. And what that means is that when I die, I've named a successor trustee to take over. Not only do I name a successor trustee to take over, I name a new set of beneficiaries, or what we call contingent beneficiaries. And the good thing about a trust is that you could postpone distribution. Remember, in a will, when you die, assets are distributed. They're distributed. If you have $1 million and you have 2 children, I give and bequeath my entire estate to my 2 children equally. It's $1 million. They each get $500,000. The son buys 5, 6 motorcycles, that's what he wants, and he squanders his money. A trust, you could spread it out. When I die, my $1 million remains in assets for my 2 children. And when my children reach the age of 35, they get a third. When they reach 40, they get another third. When they reach 45, I guess 45 is either you're mature or you're not mature. I don't know. When I reach 45, the trust dissipates. Or you could even continue it on for your grandchildren. The thing about a trust is that it avoids probate if you transfer all your property into a trust, you see. Bob Smith has $1 million. Bob Smith transfers all that cash or assets to the Bob Smith Trust. Bob Smith no longer owns it. The Bob Smith Trust owns it. That's how you avoid probate, because there's no assets. There are no probate assets. Remember, probate assets versus non-probate assets. That's what a trust is. Now, there are differences. If you have a small estate, I think a will is great. If you want to do a trust, I've seen attorneys charge anywhere from $4,500 to $10,000. That's the big cost. And usually with a trust, you still need a will, which is called a pour-over will. That's all I got. Thank you. Sorry about the PowerPoint. I kind of like the picture. I had a PowerPoint, but I like that picture.
So normally at this time, the judge, myself, and Tim would take questions. Usually do sort of the Phil Donahue style, but I think we could probably do it a little more informally, I would think. So yeah, if anyone has questions, you could just step up at the table and we'll be happy to answer any of them. Or unless you want to shout it out.
So, Judge, you mentioned that trust aren't as solid as what most people understand. So, Tim, what would you say is that? Because, I consider it trust, so I can go out when I need to go out in the appropriate manner that I see fit. I have a will, but if everything's contested, then that's what I thought.
So I had mentioned that trusts aren't always ironclad, just like wills aren't. I can give you some examples. If you pick a trustee that should never have been a trustee, if they're not doing their job, so they're not keeping all the beneficiaries informed, or they're taking care of themselves before they take care of the other beneficiaries, then you get into a situation where there's a civil action, litigation to remove the trustee. Sometimes the trust isn't written very clearly, so there may be a construction case where they come to the court and say, we're missing a paragraph, or we're missing a page, or this makes no sense. So those are the kind of issues. Now, if you have an attorney to draft the trust, you should be okay with the construction, but it doesn't always work that way. So I don't want to scare you from having a trust. Many people have trusts, but it does have it has problems the same way wills have problems.
Well, how would I know that Tim is really good at writing trust? And so I put my faith that he's writing one that's rock solid. So
we actually had a guy last week who was not even so subtle when he asked that. He was a little more blunt about how all the lawyers are cheats and liars and that, I will say from my experience in this county, I've been in the probate court I'm in my 17th year. Our attorneys are gold. We have really good attorneys, but you can look, with the internet, you're going to get comments. There's always going to be somebody grumbling about everybody, but, there's ratings. You can get information. The Cuyahoga County Metropolitan Bar Association has a referral service. There's different ways. Word of mouth, I think. What do you think? Word of mouth is golden.
Yeah, absolutely. You go to a law firm that specializes in elder planning, estates and trust. I actually happen to be, you could even go this specialization with the Ohio Bar Association. I'm actually a certified specialist for the probate, estate planning, trust.
Elder law.
Elder law, that's it. But
It's a 5-year-old. So, yeah. Basically, the asset has to be out of your name.
yes. And here's the other thing about that. First of all, Medicaid is changing.
We can hear her question.
Oh, she wanted to know, she's getting, people that are getting older, and they're worried about, having to go into a nursing home. And how do I protect my assets? My assets are in trust, right? Because Medicaid, if you know Medicaid will make you spend down. Medicaid, if you have a surviving spouse, it's a little easier because the house is exempt. The stay-at-home spouse gets to stay at home. The stay-at-home spouse gets an allowance, gets funds, so to maintain their life. It's really the harsh part is when your spouse dies and you have to go into a nursing home. Then there's a spend down. If the spend down is up to 10,000, you gotta get rid of everything. So people, yeah, exactly. You gotta get rid of everything. So, right. So you have all these houses and you have investments. You gotta spend that down. And a lot of people put it in a trust, but you gotta be careful. The trust has to be irrevocable. So you have to choose a trustee that's not you. I gave you what I call the inter vivos trust, an actual living trust. You as the grantor are alive. You are the trustee. You are the beneficiary. You have to have an irrevocable trust where you are not the beneficiary.
They can't be the trustee.
They cannot be the trustee.
No.
They cannot be the trustee. You have to have an independent trustee. It could
So
be
you're
a
really
son.
giving your money away early so that it doesn't.
Well, there's two things about that. Number one, you don't want to, I mean, I would never put my daughter on my deed. God, just to think about it, it's scary. So you got to be careful because if they could spend it, sell it.
Or if they have liens against them, they could apply.
Or if they get sued for a car accident.
That's an asset.
Yeah.
It's their asset.
That's why the transfer on death is more better because they don't take title until you're dead.
Yes.
Yeah. That comes up a lot.
They have no rights. They have no rights. So when you're distributing assets, and so the question is, and I get this all the time, hey, I like my son-in-law, I really do, but I don't trust him. I really like that. I want to make sure that my assets go to my daughter, and not my daughter to my grandkids, not my son-in-law. Now they'll spend it in a minute, gamble it away. Well, under Ohio law, the surviving spouse of a beneficiary does not necessarily have any rights. Okay? It goes by blood. Inheritance goes by blood. It goes to your daughter. Now, of course, if they're married, but it goes. If they're married, the spouse might have some influence. You know, but it's her money. It doesn't go. And if your daughter dies, it doesn't go to the spouse that's mentioned in your will. It goes to your daughter's children.
I would think you'd have to do like a very specific trust.
Absolutely.
Basically with stating all the rules and that, my son-in-law cannot touch any of it.
Absolutely not. There's no way he's getting any money.
I don't expect an exact number, but I haven't talked to probate attorneys that sometimes will suggest you don't have enough assets, that you don't need a trust.
Right.
Yeah.
Do you have a number there? I know what my assets
$1 million.
are. How much?
$1 million.
If you have over $1 million, you would just recommend a trust. Under $1 million, you could probably do it with a will and transfer from death.
One of the attorneys who spoke from Hon-Loser said he goes, I have a client that's worth $20 million and they don't have a trust, and I have one with $500,000 that does because they have a 50-year-old drug addict son.
Yeah.
So he's like, the money's not necessarily the determining factor.
But don't forget, the $1 million, that includes your house, your pension, everything that you
Sure.
So the number isn't as great as you think anymore.
Well, as I said, I go, it all depends. It's not just the money.
The trust is a way to control the money beyond the grave, right? So you're gone, but you know that one of your children has some issues and you want it to get doled out to them so that they're using it for their well-being, not for other things. So in that respect, it doesn't have to be so much money, it just has to be that you want to control it. When you get into big money, then you can use your trust for all kinds of tax avoidance, and there's different reasons to have trust. And you had asked about attorneys, just again, without throwing out numbers, there's law firms that have estate planning attorneys that are highly certified. You're going to pay more because they're in a big law firm, but you get some guarantees with that. You get somebody who's just a solo, working out of their kitchen, you're going to want to look and see what their credentials are. Because, and you want to know, do they have malpractice insurance?
Well, yeah, my concern is that that attorney passed away and it wasn't an ironclad trust he wrote. Then who do I go after?
Well, here's something interesting. There is a provision in Ohio law that nobody uses. You, with a will or a trust, either one, you can come to the court. There's a process to come to the court and have it approved while you are living. And the why people don't do it, I think, is because we have to notify anybody who would be a beneficiary or who would be a next of kin. So basically anybody that would want to challenge it, it's almost like you do a will contest during your lifetime. So if nobody opposes it and the judge talks to you and you're competent, and the court can put the seal of approval, and then that document can never be challenged. But nobody does it. And again, I think it's because
Nobody knows.
and you just don't want to bring your whole family in. I guess if you're dividing everything evenly and you know it's not going to be controversial, but then they're not going to have a will contest after you die either.
It's Susie that gets it.
Yeah, someone's going to be upset.
Susan that gets everything in the other three kids.
And you want to keep your documents. You can file your will for deposit at the court. We don't open it until you die. Nobody can see it. But that way you know it's in a safe place. You can keep it in your home. But don't just leave it with an attorney, because you would ask, what if the attorney dies? There are some processes in Ohio about what's supposed to happen when an attorney is holding files and documents. There's a process that those are supposed to get turned over to another attorney. You're supposed to know who it is, that kind of thing. But always have a copy, and even maybe a signed copy with somebody that you trust. Because we do have a lot of lost will cases where everybody knows there was a will, they witnessed it, they saw it, they know Dad had it, but now darn it, we can't find it anywhere. We can sometimes probate those lost wills if the witness is, if there's enough evidence, then we'll go ahead and probate it, even if we don't have it, or if it's torn up, or different kind of things. So that we try to cover everything. You can't cover everything, but again, the better that you plan, the less chance of there being just a complete disaster.
So you mentioned having a will or power of attorney. Is that a requirement or an option?
No, just an option.
So I can do that with a will and a trust.
Mm-hmm. Well, not a trust, a will. You can put a will on deposit.
Trust was the other thing you referenced.
Well, you can come to the court and have us validate the trust.
Yeah.
But again, you have to notify everybody that would be notified if there was a contest. So it's all the beneficiaries named in the trust and any other next of kin that would have a right to your assets. So if you're trying to do it because you don't trust somebody, and it's just you're kind of tipping them off. Yeah. The other thing, when I first came in 2009, we thought was going to be the next best thing. I didn't like it because I saw what it did to the family members in the courtroom. But attorneys were video recording the signing of the documents, right? So if one of the kids said, "Oh, they were forced into that," or "They were crazy when whatever," we had video. Well, the first trial that I had where they played this video was horrible. Everybody was sobbing, and it was just awful. And I don't think attorneys are so much doing that anymore. I've not seen it since then. But the good attorneys, the attorneys that do estate planning, they know the questions to ask. Tell me about your family, and they'll keep notes. These are the family members. Tell me about what you own. So if there is a will contest and the allegation is the person had dementia for years before that, the attorney should be able to say, well, no, they knew what they owned, they knew who their family was, they knew who the president was. So these are all the kind of things when it goes south that we try to honor. Our job is to honor what the person wanted in life.
Talk about combined. There is a family that I know that the mother adopted a child. His father has one child previously, but obviously never got his biological child. So that type of instance where the trust will be better, or how is that?
Either way, because either way you can name those people and say that I consider, this is my stepdaughter, but I consider her to be my child and I want her to share equally. We see that quite often. We also see where they like the stepdaughter better and they leave out their own kids, and that's always a will contest. one is not better than the other because both of them will list who the beneficiaries are. You can have a will and a trust. Because
Usually you do.
Yeah.
Usually you do have a will and a trust because when you have a trust, you're supposed to transfer the assets right then and there. I'll keep it at that time, which makes no sense to me. But there's always that 10 shares of Kmart stock. Or there's always an automobile that's never going to transfer to the trust. What do you do with that?
We get people.
Yeah, so the will say whatever assets I have that are coming through probate should go into the trust. So it's good to have both.
There was a lot of those trust mills.
Yeah.
And we used to have people come in my office saying like, well, here's my trust. And I'm like, what do you want me to do with that? They're like, I'm like, well, you never transferred it into the trust. They never did it. They got the trust, went back and went home, and that was it. I was like, that's just a piece of paper.
Yeah, be careful on anything that you're pulling off the internet. Trust on the internet is a definite no. A simple will, you can get the form. I would go to the Ohio State Bar Association. I think they have forms for the healthcare power of attorney and wills. I was telling a group last week, my brother, with his tax preparer, whatever he used to prepare his taxes, he got a free will form. So he and his wife did them, and they sent them to me, fortunately, before they signed them. And I'm like, so wait, you're leaving the house, Tim, if you die, your son gets the house, not your wife? He goes, no. I go, that's what it says. Like, you gotta be careful. And attorneys do not charge that much to prepare your will. It's very worth getting an attorney to do your will, and you want to follow up every 5 or 10 years. If people die, people are born, you want to make sure, that it stays up to date.
One of the things we push when they come in the office, people are always like, well, I didn't want to get an attorney. I'm like, well, I didn't want to get a plumber, but my basement was flooded.
Unfortunately here, and I know what a couple of us deal with a lot here, so we have qualities of city employees, and I'll tell you, in my 23 years here at the city, we've had over a dozen, and 90% of them die in custody. How does that, normally what I understand is that the impact of probate is dependent upon how much work then the court has to do, and whatever assets that we have a city benefit pays $100,000 to the environment to get that, plus whatever the city life insurance that we provide or we add to. But how does that diminish based on how much work the probate court has to do?
So when somebody dies without a will, we don't know anything. We don't know who their family is. We don't know if they're married. We look at the death certificate for basic information. But, so somebody has to come in, they have to be appointed to administer this estate. And the first thing they have to do is figure out who the family members are. And if they can't figure that out for certain, then there's a civil action that gets filed, a determination of heirs, and we got to pay somebody to track people down. Who are they? Where do they live? So that whole piece right there is taking time and money. Then the statute says how we start distributing that money. But that's when you get into, we've seen cases where there's kids coming out of the woodwork. Well, he never really acknowledged me, but I know him as kid because we did blood work. It just gets messy, and it takes longer, it costs more. So whatever you're having to have us handle, there's costs attached, so that's less money that the family members get. And that's the whole thing with probate. Now, if you are probating somebody's will, so somebody that you love dies and they need you to be the executor, you shouldn't be paying anybody out of pocket. If you need an attorney, they get paid from the estate, and we say how much they get paid, and we're stingy. So I just ask anybody. So we try to protect those assets for the family, but they're allowed to charge. So if it takes them 10 hours to track down where all the bank accounts are, and if it takes them another 10 hours to find family members and send certified mail and let them know what's going on, that's just less money to go to the family. So the more you plan and the more documentation you have, it's just, it keeps the money where the decedent wanted it to go with family. So.
Yep.
This is a wonderful place to be trying to hear the questions.
Yeah.
So when you get these documents, you should definitely make sure you file them with the county courthouse. Is that how that
Well,
works?
you can deposit your will for safekeeping. Okay. So we have them, they're indexed, so if somebody dies and somebody comes in to open their estate, we will do a search for that name and we'll say, oh, we have their will on deposit. You don't have to do that. And I will caution you, if you deposit your will and then 5 years later you're, divorced or you have another child or a grandchild and you want to change your will, you got to make sure you revoke that will. You have to have language in the new will that old will is no good anymore. Otherwise, we get real confused. So, but yeah, it's just a safekeeping thing. It's not required. But if you have your documents in a safe place at your home, and you have a couple people that you trust that know where those documents are, then you should be okay. Now, my parents had like 10 signed copies of everything. So my brother had a stack, and I had a stack, and my other brother. I mean, they just tried to do everything overkill, but it was helpful at the time because, again, you don't want to be dealing with that when you're going through a loss. You don't want to be finding papers and guessing. In fact, my parents had pretty much planned, where they wanted their funeral to be, what music they wanted. Please, use our money to feed everybody. I mean, that was my mom. Feed everybody. Feed people, give people rides if they want to ride. I mean, you can be very detailed and it makes life easier for the family. But at least having the basic documents. But for your bank accounts, there's no reason not to just have beneficiaries. Because, you may be still, there may be a mortgage on the house of the person who died, or there may be all kinds of things going on, and you need access to money, even just to pay the funeral maybe. So if you can take that death certificate into PNC and say, I think I'm the beneficiary of this account, can you check? And they'll look at it, yes you are, you'll get a check. So it's way easier than coming in to see us, because we try to be very efficient and do things quickly, but it's not going to be as quick as you really need it sometimes.
So if both parties die at the same time, airplane crash, those kinds of things, so the will, are you forced to probate at that point?
Not necessarily.
Because the beneficiaries are no longer.
Yeah, usually in a will it says, if I die, my wife and I die at the same time, it's as if I predeceased my wife. So you only have to probate one estate. So, in other words, you don't have to probate two estates. You can probate one estate. If you have that language in a will, usually an attorney that knows what they're
But
doing.
you have to state that.
Yeah.
And you bring up another good point, just with beneficiary designations, it's good to even have like the second line, like the contingent. So like with my mom and dad, they had all their documents, so everything went to the other one, right? And they didn't have like, but if, after the second one dies, then to the kids. So my mom died in July, my dad died in September. So when my mom died, everything just transferred to my dad, no court, no anything. But like when my dad died, then it was all probate because he didn't have the contingent, which is okay. Not everybody does, but if this person is no longer living, then it goes to these people. Then you really can avoid. Probate's not the worst. I couldn't be the executor because I know all the probate judges in Ohio, and we were trying to just keep it, like, not interfere with anything. So my brother did it, and he's a procrastinator, and he's emotional, and he just couldn't bring himself to, like, I kept saying, you got to finish this up. They're going to send you bad mail. Like, you got to do this, Tim. Everything's done. And so I got a kind of a personal view of how hard it really is when you're going through it. You're just emotional. You don't want to deal with it. Every time you have to go down to the court or sign a paper, it's bringing back the memories. So the more that you can do to get things transferred ahead of time or to make sure that's all going to just happen automatically, better it is for your family.
But harm, so you may have all the stuff. What happens for whatever reason they have?
So to some extent, you can transfer those without probate. You go to his office for that, up to $65,000. Okay, to a spouse. You can also put a beneficiary designation on title. But the spouse usually is going to get the first vehicle and maybe more than one vehicle, but up to a certain amount. So, yeah, because cars are another thing. You want to get transferred as quick as you can. Okay. Well,
thank
sorry
you.
to talk about such a depressing thing,
Yes.
but hopefully at least you have learned something and just look at it as I can make life easier for somebody else, so I'm just going to do it and then forget about it.
So I said, I mentioned, all 200 years of deeds and mortgages are all available online for download, so you could go all the way back to 1810. So I always encourage people to go to our website, pull up your deed, sure what type of deed you have, and if it, if it is a survivorship or it might not be. I've seen ones where it'll say survivorship at the top and there's no language. So that, and it's up to a judge to decide what their intent is. So just check, make sure it's what you want and what you intend to happen to your property after you're gone.
Is the affidavit automatically switched into the deed after the person dies?
There's an affidavit you file with our office stating
You have to file.
that this person died on this date and therefore it's now in the name of the
So
beneficiary.
it's not automatically.
Yeah. Well, I mean, the title transfers upon death legally, that document stating that fact. That's why I included that statement. And the affidavit in your handouts, by Ohio law, has to be of record for it to be valid. So it has to be recorded. So if if I added my son in the survivorship deed for some unknown reason, and I stuck it in a drawer, it's still a valid deed, even if I got it. He could come in years later and still file it and still be valid. That's the same with that affidavit. The legislature was very clear. It has to be of record prior for the owner's death.
Thank you all. Now
Thank you.
think about happier things.
Yeah.